We're now live.
Great, thank you. Okay, welcome to the March 1st, 2023 meeting of the Subcommittee on Family and Juvenile Law. We are going to start our meeting right now. We are going to have two bills we're going to take up, HB 267 and HB 440. And I don't believe there's any other housekeeping notes right now. Again, welcome to the meeting. We are going to bring in our guest right now because we're going to start with HB 267 with any questions. And our guests that we've invited for 267 are Libby Snyder and Michelle Smith. And if you'll go ahead and let them into the meeting.
Yes, I'm letting them in.
Okay, great. All right, and so while they're coming in, why don't we ask our committee counsel, Lauren Nestor, to go ahead and give us a quick summary of the bill. And I do know that the committee members should have amendments that are, you may have two different formats of the amendments, and you may also have some written testimony from one of the witnesses that was unable to appear today. So anyway, you should have those two items with you, but go ahead, Lauren, and just summarize the bill for us, if you don't mind.
Okay, the bill authorizes a court in a custody or visitation proceeding to require a party to provide advance written notice to the court and the other party of the intent to travel outside of the United States with the child. It also authorizes a court to order abduction prevention measures in a child custody proceeding if the court finds that the evidence establishes a credible risk of abduction of the child, and it establishes procedures by which a party or another individual or entity may file a petition seeking such measures.
Okay, thank you very much. And does the committee have any questions? I do believe is Libby and also Michelle Smith, are they on in the meeting now?
Yeah, Libby is on, but not Michelle.
Okay, all right. Does the committee have any questions right now regarding this bill? Okay, let's see if I can see any questions. All right. All right. Okay, you know what, before we do that, let's talk about the amendments as well, so just people kind of understand.
Hey, let me pull up the amendment.
Yeah, and that may be, okay, while we're doing that, I'll go ahead and take the question. Go ahead, Delegate Simpson.
So the only question I had was the part about, or are we just talking about the amendment and not the bill?
No, we can talk about the bill first, and then we can talk about the amendment, and then we'll get into next stages from there.
All right,
yeah, go ahead. Let's talk about whatever your questions are generally about the bill.
So it was only the section, let me pull it up. It is the specific section that talks about providing information to the other parent, specifically like about bank accounts and things like that.
Mm-hmm.
And my first question was, is this a model from somewhere else? Like, where did we get the language in general? That's my first question. Is this like copied from somewhere else?
Okay. And I know Delegate Bartlett, the bill sponsor, obviously is a part of our subcommittee, and I'm not sure, Delegate, if you want to answer that question.
Yes, thank you, Madam Chair, and thank you for the question. So the bill is, yes, we have done, we have made an effort to implement the Uniform Law Child Abduction Prevention Act, known as UCAPA. So you might hear someone today say UCAPA committee, so this subcommittee. So just let you know that that's what that's referenced to, and it is a uniform law. So the amendments that we've made, or the issues that we brought up, were based on the uniform law. Some of them have been addressed clearly and cleanly, and some of them are just a little bit particular to Maryland drafting.
Okay, do you want to talk a little bit about the amendments based on that? Because I know the amendments are pretty long, and I'm sure most of us have probably not dived too deeply into them, but maybe along with Lauren, and I don't know if Libby may be able to help, if you guys can just kind of describe what those amendments are, and
Yep.
that'll be helpful going
And
forward.
Libby is definitely a go-to person, of
Okay.
course, Lauren, but she is definitely a go-to person because she is from the Uniform Law Commission, and she's part of the folks who wrote the UCAPA.
Okay, great. So Libby, would you like to just provide the subcommittee with an overview of what the amendments are, what they do, how it changes the bill?
Yeah, sure.
Great.
First,
Thank you.
I want to recognize Delegate Simpson. There are two different parts that mention asking about bank accounts, et cetera. One was in the initial bill as introduced in the section talking about mediated custody agreements and divorced parents who have foreign citizenship requesting to travel abroad. And that makes mention of, one parent having to provide the other with W-2s, financial statements, their salary, stuff like that. And that section actually did not come from UCAPA, and so I'm not the expert on that. However, and now I'll dive into the amendments, which also have portions that talk about bank accounts. The amendments sort of lay on top of the bill as introduced and implement additional sections of the Uniform Child Abduction Prevention Act that were not in the bill initially. And those sections are specifically Section 7 and 8 of the Uniform Act. Section 7 of the Uniform Act, which will in the interlineated amendment copy, it's Section 9.7-107. And that lists factors that a court may consider in determining whether there's a credible risk of abduction of a child. And those factors sort of fall into three buckets. One are actions by one of the parties. So whether they've previously abducted or attempted to abduct the child, threatened to do so, engaged in what's called abduction planning activities. So abandoning their employment, selling their primary residence, terminating a lease, closing bank accounts, applying for a passport or visa. Another bucket that it could fall into is lack of ties to Maryland or to the United States, and the existence of strong ties to another state in the United States or another country. And a judge can kind of take those two factors and look at them together. And so if it's a person who, maybe has only lived in Maryland a very short time and all of their family lives in California, for example, and they have very strong ties there, a long history there, that could be looked at as one factor. And then similar to that, if this is a parent who has strong ties to another country, that can also be looked at as a factor that may indicate a risk of abduction. And then the third factor would be, or the third umbrella term, I guess, would be laws in another state, laws in another country, and, the existence of a diplomatic presence in another country, whether another country is a party to the Hague Convention, and, sort of that umbrella, which is looking at international law and to what extent that may indicate a risk of abduction. And if it does, what are the risks associated? Does it pose a great risk to the child if they go to that country? Would going to that country indicate that there's a higher risk of, it would be more difficult to get the child back because there aren't, strong diplomatic ties to that other country, et cetera. So those are sort of the three main buckets that a judge can look at when determining whether or not there is a credible risk of abduction. And generally speaking, the thinking is that the more factors that are present in a particular case, the more likely an abduction will occur. And then the other new big section is Section 9.7-108. And what this does is it lists quite a few measures that a judge can impose in a child custody proceeding to prevent abduction. And those could be things like, travel restrictions. So saying that you can't travel with the child outside of the state or outside of a certain geographic area, or the travel restriction could say that you can't travel outside of the country. Or, if the situation, isn't as, risky, a judge could allow the travel to, another state in the United States, but require that traveling parent to provide, a very long and robust itinerary with addresses and contact info. They could prohibit removing the child from the state or the United States. They could require supervised visitation, prohibit, picking the child up from school. They could put the child's name in the U.S. Department of State's Child Passport Issuance Alert Program. Lots of different things are listed in that section. I don't want to take too much of the committee's time, but I'd be happy to answer questions if there are particular questions. And then finally, in that section, it mentions that in an abduction prevention order, to prevent imminent abduction of a child, the court may issue a warrant to take physical custody of the child. And that's usually saved for situations where, say, a parent is on the way to the airport with the child to travel internationally to one of those countries that may pose a great risk. And, it would take years to get the child back. And so you're trying to just stop that from happening so that that doesn't have to happen. And you don't have to go through years and years of legal challenges to get that child returned home.
Okay, thank you very much. Delegate Simpson, did you have another question or?
Let me see if I'm still on. Yeah, I'm still on. Okay. Yeah, it was just that section. It's on, it looks like it's on page 6, line number 14, F and 1. And it goes on, and I don't have I'm just thinking in a domestic violence, of course, situation. Obviously folks who have irreconcilable differences, people, these are, from my experience, these are very heated. You have individuals who are saying, hey, they're taking the child because we're not protecting them. And so they're trying to protect them. And they can be very tricky as to figure out who is the victim and not. It's just that I don't have a problem if they provided all that to the court, but providing that directly to the non-traveling parent. Does that make sense? That's some serious information, bank accounts and stuff like that from somebody you already don't like.
Well, it sounds like, and maybe Libby, you can answer this question. It sounds like if we're following the Uniform Child Custody Jurisdiction, what is it, Enforcement Act, are those all parts of what would normally be under that act? Or are you saying that that's out of your area?
Well, the UCCJEA is another area that I do know about. I will say that this language that Delegate Simpson mentioned in particular is not from any uniform act. And in fact, one of the person who submitted written testimony to the subcommittee discussed in her written testimony why she believes that provision is problematic. From my perspective, from a Uniform Law Commission perspective, that is outside of the language of UCAPA. And so I feel like the situation that language is trying to get at is likely covered in UCAPA, and that it seems to be drafted fairly narrowly to apply to a very, very, very small subset of individuals, which would be individuals who are divorced and have held foreign citizenship and have entered into a mediated custody settlement at some point and wish to travel internationally with the child. And so that's kind of a lot of factors that one person must satisfy in order to fall under this section of the law. There's slightly similar language in UCAPA in those factors to determine risks of abduction, but it's not as directly tied to divorce, holding foreign citizenship, and situations like that. But it would also allow a judge to look at, whether a person has terminated employment, sold a primary residence, terminated a lease. It's just not quite as specific as this language.
Yeah, because it sounds like this is going to the totality of the circumstances, because we're talking about visitation, we're talking about, custody periods. These are all the times and that this bill is really related to, those kinds of periods of time. So, okay. Does anybody else have any other questions right now? Any concerns, anything you want to just raise right now? Since Ms. Snyder's in the guest chamber with us.
I don't
Okay,
know. I
Go
don't know.
ahead.
I don't know if this is the right time, and I'll hold it if necessary, but I move favorable on this bill.
Yeah, it's not quite the right time. Yeah, I'm just trying to find out if we have any other questions, and if we don't, then we can certainly let Ms. Snyder go. Delegate Bartlett, did you have a question? I did see your hand go up once before. Go ahead.
Yeah, it went up, I put it back down, and now it's back up again. And I wanted to say that, I know you had an opportunity to share Ms. Kaczynski's letter. And in that letter, she does mention, in relation to, or kind of continuing with Delegate Simpson was saying, that she did feel that it was a little bit too much information. That was what was in the original bill. And I am more than happy as a sponsor amendment to not include that in the bill. I am more than happy to make Maryland's law look as much like UCAPA as possible. And also, one thing that we might need to do, and that might satisfy some of the bill drafting convention that we need to have, is we can reference where some of Maryland law already exists. So we have already, had our bill hearings. This is already established law in some places. And so what we were trying to do was incorporate UCAPA within Maryland law. And perhaps the easier and cleaner way, and Lauren can advise on this, is if we make a cross-reference to those sections where we already have it in law. And in fact, we have all the sections. In bill drafting was kind enough to provide with me with all the existing sections. And also Ms. Snyder was kind enough to look at those sections that bill drafting is mentioning. And if we needed to, we could do a double cross reference. So we would reference on our bill that we're trying to make look like UCAPA, we could reference the family law section, as well as in the family law section, in the family law itself, it could be updated to include the information that we need. And I want to make sure, Ms. Snyder, that is what you gave me. And is that where you were going when you gave me the red line copy yesterday with the Maryland law?
Yeah, so the red line copy just looks at law that was incorporated into the bill draft. I didn't in that red line cite to any of the existing statutes that the bill drafting agency sent to you.
Right.
And I agree that there are definite situations, especially where they mentioned that there are provisions in existing law that would cover something. The only one gap that I would mention that I noticed this morning, so I hadn't had a chance to email you yet, is that the bill drafting agency noted that Section 9 of UCAPA on the warrant to take physical custody of the child appears in 9.5-311 of the family law article. And that's a reference to Section 311 of the Uniform Child Custody Jurisdiction and Enforcement Act. And it's true, those Section 9 of UCAPA and Section 311 of the UCCJEA are drafted very similarly and are intended to essentially mirror each other. But the one note that I wanted to make is that Section 9 of UCAPA was put in there because it authorizes that issuance of a warrant in one situation beyond what the UCCJEA does, which is in the emergency situation. It allows that warrant to be executed regardless of whether there is an existing child custody determination. So the UCCJEA only applies when there's that existing determination. UCAPA could apply in the midst of a child custody proceeding when that final determination has not yet been made, if one parent is attempting to flee with the child. And then to Delegate Simpson's point really quick on, domestic violence victims and how would this work? Could there be a risk of, a parent trying to protect their child, but being stopped sort of by UCAPA? And in Section 7 that lists the factors, it does provide that in a hearing on a petition under UCAPA, the court is required to consider evidence that, that respondent's conduct was necessary to avoid imminent harm, and any other evidence that may be, necessary to determine the risk of abduction. And, it was very important to the drafting committee that we take into account that sometimes a parent is fleeing with a child to avoid a worse situation, to avoid domestic violence, to escape domestic violence. And we do not want UCAPA to stand in the way of those types of situations.
Okay, thank you very much.
Thank you.
I just have a really quick question. Do you know what other states have similar legislation?
Yeah, similar to UCAPA, there are 14 states and the District of Columbia. In terms of Maryland's neighbors, Pennsylvania also has UCAPA. And I know that I'm working with the bill drafting office in Delaware right now to get a bill introduced this session. And so there's a chance Delaware could have it as well. I will pulling up the little map right now. It goes quite broadly across the country, but if you have Pennsylvania, DC, Maryland, and then soon Delaware, all following the same law, that would probably make things a bit easier for courts. The other states that have adopted UCAPA are, it's loading.
It's okay. I mean, if the 14 states in the DC and then telling us about the region is fine. Thank you so much.
Okay, great. All right.
Definitely. Okay, any other questions? Okay, well, Ms. Snyder, I think that we can definitely release you and appreciate you being here with us today.
Thank you very much for your time.
You're welcome. Okay, and committee, it sounds like we still have some work to do on this particular bill. So I think we need to hold it to allow Delegate Bartlett to do a little further work on this, especially on the amendment side. Like I said before, it's a long, detailed amendment, and I really want people to understand what it really means and how it will be important to this particular legislation. So, okay, let's go on to HB 440.
Okay.
Okay. And while you are letting in our guest on that one, Lauren, would you mind just giving us a real quick summary on 440?
Sure. Would you like me to explain the bill with the amendment proposed or just as it was introduced?
Yeah, why don't you do it with the amendment proposed?
Okay. As proposed by amendment, the bill would require a court in a custody matter to set an expedited hearing on a petition regarding a proposed relocation of a child that would significantly interfere with the other parent's ability to maintain the predetermined parenting time schedule.
Okay, so did everybody get that? Okay.
One more time, please, Madam Chair. I was listening. It's just dense.
Sure, it's okay.
Okay.
Lauren, would you break
Sure.
that down for us a little bit?
Sure. So it's basically just saying that the court needs to set an expedited hearing on a petition regarding a proposed relocation of a child if that relocation would significantly interfere with the other parent's ability to maintain the predetermined parenting time schedule. It's basically just requiring an expedited hearing for these types of petitions.
Thank you.
Okay, do we have any questions about this? And do we have Lori Ruth in the meeting yet? Let's see. Did we have Lori Ruth in the meeting yet?
Yes, I'm here.
Okay,
Yes.
okay, great. All right. Does anybody have any questions regarding what this bill would do? How it would be, what's the mechanics on it, Lori Ruth?
So, it's an interesting little bill. I think quite honestly, it might not do what the sponsor was intending. It's not clear to me. Michelle Smith was talking to Senator Carter's aide about these amendments because the way it was drafted, we felt that 40 miles was pretty arbitrary. I mean, I drive 40 miles to come to Annapolis, And people, do that regularly. But the way it's also the statute that it was put into is a statute that says a judge may put in a court order that if they intend to relocate, they have to give notice to the other party. And if anybody then petitions the court, they have to have an expedited hearing. And this adds, as drafted, it added sort of a second, what I would a little bit call, and I really mean it portion that said, and if it's going to be more than 40 miles, the court shall have an expedited hearing. So I think the intention there was that they wouldn't have to file a petition in some way, but that's not procedurally how the court works. The court would need to know. So somebody would have to file something anyway. Do you know what I mean?
Mhm.
So Senator Carter's office seemed to agree that 40 miles was pretty arbitrary. And so they accepted the suggested language for that amendment in 4.2, so that the court could set a hearing, an expedited hearing, if it's going to interfere with somebody's child access or visitation or custodial rights. And that's what the amendment well, now let me see if this matches what I understand from the Senate side. I might not have seen these now that I'm reading that. Just a moment.
Okay.
If I can help,
Yes, that'd be great.
my understanding is that Delegate Charles' amendment would make the bill identical to the Senate cross-file.
Okay. So it is the same. So the page on line 1, the amendment number 1 just matches the statement at the beginning, and the amendment on line 2, amendment number 2 is the changing it from the 40 miles to that would significantly interfere with the other parent's ability to maintain the predetermined parenting time, because we thought that gave the court, maybe it's 35 miles, but for some reason that's way worse than a 50-mile change for, I don't know, highway construction. I can't think of it, but something like that. So that was that language, I believe, does match what Senator Carter said. What's not on here is the second amendment that Senator Carter had agreed to in principle, but then at the hearing said she had changed her mind. And that's in the Women's Law Center's testimony, and it's in the Family Law section's testimony that would remove page 2, lines 24 through 26. And the reason is this language takes away the judge's discretion to make a decision about whether the move was in the best interest of the child. It says it may not consider any time spent on relocation to be advantageous in that party's subsequent custody hearing. And the conversations that were had with Senator Carter's staff were, they're going to use a best interest of the child standard, which is what they should use. And like I said, she had agreed to remove that, but then I think changed her mind when maybe she had time to think about it. I don't really know. So
Sorry to interrupt, but that is out of the bill by the amendment submitted by Delegate Charles.
Yeah, I was going to say, I thought I saw at the end of his amendment. Could you put that back up, Jeremiah?
Yeah.
Oh, maybe I'm not seeing it.
It was striking lines 11 through 26, which is what I think you just mentioned, right?
Lines 11 to 26?
Lines
Or
24
to 26.
through 26. are
Okay,
out.
so that is the second amendment that was agreed to. So that does match what Senator Carter had agreed to, if the second amendment.
Yeah. So if you're looking at it now, at the end, it says, and it strikes in their entirety lines 11 through 26.
On page 1, I'm looking at page 2, lines 24 to 26.
Okay.
They're out of the bill. That language has been stricken from the bill by this amendment number 2, which says on page 2,
Mhm.
then the last sentence, and strike in their entirety lines 11 through 26 inclusive. That includes lines 24 through 26. So they're out of the
Page
bill.
2. Right.
Okay, so it is still, however, a little different because we hadn't considered striking 11 through 23. So let me just
It's okay because 11 through
It's-
23 is just
Yep.
current law, and it's not repealing it from the law. It's just taking it out of the bill.
I get exactly what you're saying. Yeah, so
Go back to the bill, Jeremiah, if you don't mind.
Yeah, that makes perfect sense. It just takes me a little while to catch up sometimes when
Yes.
I'm reading amendments.
It's okay.
So the amendments were what the family law section suggested as favorable with amendments and what the Women's Law Center suggested as favorable with amendments, just to make it more workable for the court and not really so restrictive to the judges or to the parties about this 40 miles. Does that make sense?
Okay. Page 2, yeah. Okay, so we're striking lines 11 through 26. Okay. All right. Okay. All
That
right.
is different from the way the Senate, the way that it was proposed in the Senate. But I never saw actual amendments from Senator Carter. She had just agreed to them. So I don't know if Delegate Charles, knows what's going on, but I guess my initial thought is if you take out 11 through 23, I mean, we, these ones that are now are existing in law, you're just saying it comes out of the amendment, not out of the actual law. Is that what you were saying?
That's right. It comes out
Okay.
of this bill and it still
Yeah.
remains current law.
I
So
see.
It's just striking it out of this bill as if it
Yeah.
never. Yeah.
So that's fine. That would then match the Senate version if they haven't voted on it yet. But it addresses the concerns. And the other thing about this is that it actually doesn't affect all that many people, because you have to have an order in existence that already says you have to inform the court if you're going to relocate. So it's not for every custody case that goes to any court in the state of Maryland, the way I read it anyway. It's only within the context of the beginning of the statute that says a court may, on page 1, lines, I guess 20, a court may include a condition that they have to give notice. And so it doesn't, I don't think it is going to flood the courts with people. When we see relocation cases, I understand Senator Carter's concern that people leave thinking, and then I'll get that other parent out of this child's life. And we don't want to see that, except in exigent circumstances when somebody leaves for safety reasons or something. And the court would be able to consider all of that in the best interest of the child. But oftentimes people leave because they have no support system in Maryland and their family is in the other state and they have a job waiting there and they have, childcare available if they move back to where they came from, for example. So there are facts that a court would consider in the best interest of the child if somebody is planning to relocate, whether it be, like I said, 35 miles or 2,000 miles.
Right. And that doesn't take that away at all here.
Right.
Okay. So let me go to some of the other delegates who have questions. Delegate Simpson, I think I saw your hand up, and then Delegate Bartlett, and then Delegate Taylor. Delegate Simpson, you've got to take yourself off of mute. Uh-oh, you're still on mute. Okay, while you're figuring it out, let's get Delegate Bartlett up. Go ahead, Delegate Bartlett.
Thank you. So I want to go back to the amendment and the section amendment number 2, where the last portion, the last phrase, and striking their entirety, lines 11 through 26 inclusive. I understood, Lauren, what you were saying, but I think this is very confusing. And it's confusing because it does appear, when we're striking that, I understand that it is existing law, but it looks as if.
Go back to the text of the bill, Jeremiah. I'm apologizing, Delegate Bartlett. Yeah, go back to the text of the bill so we can see what you're referring to, Delegate. Go ahead, you can continue talking.
But in striking that, I understand what Lauren was saying, but what I'm concerned about is it seems that we're removing that from existing law. So my question, I guess, to Lauren is, in drafting, what is that going to look like in the bill? Are we just not going to, when we do the bill, are we just going to go from section, from one section to the other without including that information? Or, 11 through 23, do we just take it out? I mean, I'm not sure what that looks like, because normally it just seems like to me that amendment, having that last phrase in there should be clearer on the amendment to state, I guess we're really only wanting to get rid of 24 through 26.
Mhm.
Yes, I will, while we're going through this, I'm going to try to send around to Jeremiah. I'm going to try to email him a reprint of this amendment so that you could see it with the lines, how it would look in a interlineated copy. And then I think it will be a little clearer that it's not removing it from the code, because there's also a function paragraph that makes that clear as well. So if you can give me a minute, maybe with other questions, I can try to have him pull that up.
And in fact, we should have sent that to you. I think we did send an interlineated copy, if I'm not mistaken.
I'm not sure we had it.
No,
It came
we-
in a
we-
little late,
okay.
so I didn't have a chance yet to do it, but
Okay.
I'm gonna send that around in a moment.
Okay, thank you. Okay, Delegate Simpson.
So what we're saying is by striking that, we're taking out that the court won't consider that time. I mean, I know that's an issue because you take the child, you've had the child for 6 months, they're in school and all that. The other parent is like, it's kind of goes along with what we were talking about before with the abduction, for them not to say, well, now you've been with this other parent all that time, and therefore we don't want to disrupt the child again.
If you're asking me, I agree with you. The purpose of the language that was in the original bill is that fear that the person relocates, and by the time the court finally gets around to talking about it, they've achieved what we often refer to as a new status quo. So
Correct.
now the kid is in North Carolina, they're enrolled in school, they're well ensconced, and the judges say, well, he's well settled in North Carolina, I'm just going to leave him there, even though mom or dad shouldn't have gone there without filing for a modification first in court. So I understand the problem, but the language really restricts the judge from being able to say, the parent shouldn't have moved without telling anybody, and that's bad. But in the best interest of the child, I'm now going to do that analysis and say that it is in the best interest to let the child stay in North Carolina. And this would disallow the judge, the language that was put into the bill would disallow the judge from ever saying it was in the best interest of the child to stay in North Carolina. So it's too, it was too restrictive. We wanted to maintain the best interest analysis that a court could do. And that's why we asked it to be struck. Does that make sense?
Yeah, it makes sense. I just know the purpose of why it was there.
Yeah, that is the
Um,
purpose.
And I don't know that, are we addressing that? Are they really making a decision about, I guess, the best interest? These are the hard cases you don't like, and you do feel
Right.
like,
Well, and I mean, I suppose it could be rewritten, and I am not a drafter, so I will defer to somebody else. But it could say a court may consider, but it's not dispositive, is what I want to say.
Right, I
Lori,
was just wondering if you're
hold
from
that thought, Lori Ruth.
the
and
delegate Charles.
Let's go back to Delegate Bartlett's question. And Lauren now has the correct format.
Yeah, I just put it up.
Thank
Okay.
you, Jeremiah.
Mhm.
So just to explain a little bit how it works is on what Jeremiah is showing there on page 1 in line 12. that is called the function paragraph, and it's now showing that the bill that is being affected is 9-106A only. So if you, Jeremiah, please scroll down to show 9106A, and then if you keep going on to the next page, please. Thank you. So A ends there after line 10. So we're only making an amendment to lines 7 through 10. And then starting at line 11, where all that language is stricken in B and C and D, and the new lines 24 through 26, that is now out of the bill, but lines 11 through 23 are still part of the law. There's just no, it's 100% clear that we're not repealing that from the law, because the function paragraph specifically says that we're only making an amendment to 9106A. So B stays as it always was. So the effect is really just to remove that whole thing from consideration, as if it were never drafted, as if you never saw lines 11 through 26.
Okay. Delegate Bartlett, does that answer your question?
Yes, I get it now. Thank you so
Okay.
much, Lauren. You were right. It
Okay.
does make sense when you see it this way.
Oh, okay. I'm glad. Thank you.
All right. Delegate Taylor, I think you had a question.
I did, but you guys just answered it by showing us the amended language. And I think that Delegate Charles will, anxious to hear what
we'll
he
get to
has
him.
to say. Yeah.
Absolutely. All right, Delegate Charles.
All right, how are my good friends over here doing and the Family Law Committee?
Waiting for you.
Yeah, listen, no, I
Very
appreciate
familial. We're very familial.
Yeah. Listen, I appreciate you all. And the rationale behind this bill, as I stated in my testimony earlier this month or last month, was about, having some level of accountability in this, and that wasn't there. I've spoken with a few family law attorneys, and this is a real issue that's happening, where folks are taking children across state lines, taking them into other jurisdictions, violating custody orders that are awarded by the courts, but they're violating them and there's no consequence to it. And it's as if they get a handshake to say it's okay to take the child. And so that's why a lot of that piece of the court may not consider a child's time spent with a party who relocated in violation of the section to be advantageous, because that's exactly what it was. But we were willing to come to a level of compromise to move this out. That doesn't change the fact that that is a real issue, and we may have to come back to reconsider that at a later date. But that is a real issue. The courts take that into consideration and say, in the best interest of the child, they've already been in another jurisdiction. And I understand where the Women's Law Center is coming from, but we have to be fair and partial with a lot of the bills that we're doing. And I'm hoping that this gets to helping alleviate some of the problems. We've put the bill in the same posture as the Senate. We've worked with the Women's Law Center on that bill with Senator, with the Senate, and also with the Family Law Division of the Bar Association. Yeah,
So Delegate Charles, let me just interrupt really quickly. The real goal here is to expedite hearings, right? To do an expedited hearing when there's an issue that comes up, right?
That's correct.
Okay. And as far as we can tell, this bill covers that. I mean, I don't see where there's other issues outstanding, but the whole point is to make a way for the parent to get to court to say, my child is now in another state and I need to do something about it.
Exactly.
And I guess my only question is, and this would go out to, it can be answered by Lauren, it can be answered by Lori Ruth, and that is, I think this bill accomplishes that, and I just want to make sure it does. I do believe it accomplishes that.
I believe it does. The 40 miles, was very stringent. It was very a stern piece, but by allowing to have the current amendment that we put in place, that anything that impacts the time the child is spending with the other parent based off of the custody order. So I think it opens it up and makes it more amenable. I was trying to be very specific, but I like the new amendment that came in. So it's definitely doing what we're asking for to get that in front of a judge in a faster fashion. So.
Okay. All right. Anybody have any other questions regarding the bill, the posture, amendment, or anything else right now? Okay, well, I don't see any other questions. So I appreciate our guests for being here. And you, Delegate Charles, and Lori Ruth are definitely welcome to leave, and we will continue on with our meeting. Thank you.
Just a quick thank you and a quick thank you to Delegate Charles and Senator Carter for being willing to listen. We really appreciate it. Thank you.
All right. Thank you.
Thank you.
Great. All right, committee. It sounds like we've at least got 4:40 to decide what we want to do next here. And I'm going to just go ahead and ask if we have a motion on this bill.
Move favorable, Madam Chair.
Okay, thank you. Do I have a second?
Second.
Okay, thank you. And is there any discussion regarding first of all, I apologize. We need to go back. We need to move the amendment first. My apologies.
Okay.
So do we have a motion on the amendment?
Move the amendment.
Do we have a second?
Second.
Thank you. All right. And I think we just do a verbal vote on the amendment. All those in favor of the amendment, say aye.
Aye.
Aye. Any nays? Any exemptions from it? All right. So let's move on the bill. Do I have a motion to move on the bill?
So move, Madam Chair. I move favorable.
Thank you. Do I have a second?
Second.
Okay. Any further discussion?
I have some discussion,
Sure.
Madam Chair.
Sure thing.
Now that we've modified pretty much the entire bill, we've taken out lines 11 through 26. We really have changed the spirit of the bill. And I know we just talked about this with Delegate Charles. And
Sure.
I know that last line really meant something to him personally and otherwise. So, and I'm talking about that part where it talks about considering a child's time spent with the party who relocated. I hate to miss opportunities, right? If this is a real issue,
It is an issue.
Is there some way, or are we out of the time? I'm still new, so I don't know. Is this still amendment worthy even after we vote today, to be able to consider maybe this language in a way that would be acceptable, to get it out of the chambers?
So if you have an additional amendment, or you want us to consider an additional amendment, then this is the time for us to do that. Excuse me. So we can certainly do that. We can hold the bill if you have an amendment coming. Is there something else you want to discuss further about the bill? Let's do it right now. We can
Okay,
talk.
so was the Senate then, the Senate version,
Mhm.
did it take out this language and that's why it got through the committee in the Senate?
So the Senate, I understand, has not voted on the bill yet, but they do have an amendment, the same amendment. And Laura, you may have more detail on it than I do.
Yes, and I will get right back in a second. I'm just going to check and see if
Sure.
the internet status has updated anything new from the Senate. I'll be right back.
Okay, no
Yeah.
problem.
Just wondering if this was,
Sure.
if it was problematic, and, Delegate Charles just said it, he took it all out as a compromise. I just wondered if it was a real showstopper and if there was some way still we could manage to have this language or at least the spirit of the language included in this bill.
Okay, and when you say the language, are you referring to putting back in the language?
No, I don't mean to. I know
I'm
we've
sorry.
taken it out. I don't know if it was the way it was worded
Mhm.
or if it was the nature of the language, meaning we took it out because we didn't think the courts could manage it, or we took it
I
out
got you.
because it didn't make
Okay.
sense, or is there a way now to recraft that language that would still have the courts not consider a child's time spent with a party who relocate? I mean, to me, it's very clear. But I guess I'm really wondering, we took it out. He made a compromise.
Mm-hmm.
Is there some way we can massage it to get it back in, or do we have to really wait until the next session to maybe introduce a whole new bill with this particular language?
I mean, it is an issue that's been going on for a long, long time. And it does happen. I think maybe the issue is about prohibit, in the very original sentence, and then saying may not consider.
Chair Crutchfield, may I interrupt? And
Yes, go ahead.
just to inform the subcommittee that the bill, Senate Bill 42, passed out of the Senate. It is now in the House. And first reading in the House, and it passed in the identical posture as the amendment that Delegate Charles has submitted. So that language, lines 24 through 26, has been stricken in the Senate version as well.
Gotcha. So what would happen then procedurally, Lauren, and just make sure I'm correct on this, is that if we change it from what we currently have right now, the bill would be identical to what the Senate bill is that has come to the House floor, or is coming to the House, to our committee, in fact, and to the House floor. If we change it further, then the bills will be different. And then what will end up happening is ultimately the bills would have to go into a conference committee. And at that point, decisions would have to be made about what to do next with the bill. So that's procedurally, Delegate Taylor, what happens now. If there's something more that you want to do with this bill, or you really feel that we need to make a change here with this subcommittee, we can still do that. I mean, and again, it just won't be the same bill. And it just means that, there'll have to be a conference committee to try to get the bills aligned with each other. But if there's, and so that doesn't prevent us, let me just make that clear, from doing anything here. I just want you to know procedurally what happens next, okay? And it's okay for us as a subcommittee to create amendments onto the bill in addition to those that have already been approved and voted on, okay? So we've got the sponsors' amendments. We already approved that amendment, but if there's something more we want to do here, we can do that, okay?
I appreciate you, Madam Chair, for that,
And would you like for us to hold this and I don't know, Delegate Simpson, if you might want to work with Delegate Taylor, or, how you want to do this, or Delegate Taylor, if you want to work with Lauren, or all three of you together, to maybe come up with another amendment. I'm not opposed to doing that. Is that something?
Is that okay for me to?
Yeah, go ahead.
Sure. Having heard your explanation, knowing now that we've already gotten out of the Senate with this version, I would be willing to stand down on, but just know that, I have some unrest. I know Delegate Charles has some unrest. I just wanted to acknowledge that and find out what the procedure is. And you very astutely laid that all out for me. That's really all I needed to know. So thank you. And I'm ready to take the vote if you're ready. Thank you.
All right, no problem. All right, so that's what we will do. We had a motion, a second, and we'll go ahead with our vote. And unfortunately, let me get ready because I was so involved with everything else. Let me go ahead and pull up everything, because I like to do this alphabetically, so we make sure that we get all of our members. So let me see. All right. So what we will do is, as we have done in the past, and that is to go around alphabetically and just vote on the bill. So we will start with Delegate Bartlett.
Aye.
Okay, Delegate Boucher.
Aye.
Delegate Kaufman.
Aye.
Delegate Pastor.
Aye.
Delegate Simpson.
Aye.
Delegate Taylor,
Aye.
Delegate Tomlinson, and Delegate Valentine.
Aye.
Okay, and myself will be favorable as well. Thank you. And Jeremiah, could you tell us what that vote count is at 9, 9,
So it's 1, 2,
or 8? That's probably 8. Yeah.
8.
Okay.
And we missing, I didn't hear Valentine, I think.
Yes,
No.
aye.
Okay.
Delegate Tomlinson.
Tomlinson's not
So
here.
Delegate Tomlinson and
Yeah,
Delegate
Tomlinson. Yep.
Simmons are not present.
Correct. All right.
Okay, great. All right, well, I think that concludes our meeting for today. So do I have a motion to adjourn?
So move.
All right, and a second. All right,
Second.
great. So thank you very much. And the hearings start at 1 o'clock for the Judiciary Committee. All right, everybody.
See you then. Bye-bye.
Thank you very much.